Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Aaron Yeater. Today's episode is, What's the Data Protection Difference? An EU-US comparison of personal data protection issues in merger and behavioral investigations. As most of our audience will know, sensitivities over the ubiquity, use, and intrusiveness of data collection pervades a variety of legal issues and areas. One area that has gotten perhaps less scrutiny is the role that these data play in assessing mergers and other investigations of potentially anti-competitive conduct. Given the separate EU and US legal regimes that govern those investigations also take different approaches to data, it may be useful as practitioners to anticipate different priorities and practices, and so we want to focus on those differences today. My co-host on today's show is Matthew Hall. Hi, Matthew.
Hi, Aaron. Our guest today is Dan Rupprecht. Dan is a U.S. qualified lawyer who has practiced in the U.S. and Europe. He is now the Director for Europe of iDiscovery Solutions, or IDS. During his time in private legal practice and now in the e-discovery service industry, he has advised and managed high-profile projects through all phases of the EDRM process, that's Electronic Discovery Reference Model. This includes large-scale document reviews related to merger control reviews at Phase 2, cartel, abuse of dominance, and state aid investigations, internal investigations, and multi-jurisdictional competition or antitrust litigation. Hello, Dan, and welcome to the show.
Hi, both, and thank you for having me today.
Thanks very much for coming on. As Aaron mentioned in the introduction, our focus here is on the implications of the collection of personal data. Can you just describe to us what we're talking about here when we talk about personal data in this context?
Really, it could be just about anything. It's got such a broad definition in terms of any information that identifies an individual. This could be email, this could be information about an individual, this could be information that leads to an individual. It really proliferates all our various digital environments and everything that we work with. So again, a very sort of broad application of the term, but in essence, it's just anything that can lead to an individual and the information about that person.
So looking at M&A or merger and behavioral antitrust investigations, what are we talking about today? Why is personal data increasingly of importance and relevant? When we think about data, we often think of reams of data just purely on costs, prices, margins, etc. Why personal data?
So it's an actual good point that we're bringing up in the early stages, and this will infiltrate much of our conversation as we work through the various topics, and most of that is built around the differences between merger and acquisition investigations versus sort of behavioral investigations. But at its core, all the information that we deal with in either of these scenarios are housed in large volumes of digital information or electronically stored information, ESI. In mergers and acquisitions, we are taking a kitchen sink approach. And for any organization that needs to understand their environment, their digital environment, they need to collect and process vast amounts of information, which will inherently contain personal information when you take that such broad stroke against the data. On the behavioral side of things, this becomes even more pronounced. In behavioral investigations that might deal with agreements in a cartel or abusive type of situations in organizations that hold a dominant position, a lot of these investigations are built around communications, built around relationships. And because of that, we have again, an inherent interrogation of individuals and their communication streams. So very personal in that sense. So on both sides, you're picking up a lot of this information, which requires us as practitioners to tread lightly across that spectrum.
Okay, that's very useful, Dan. I think you used the word inherently in both of those contexts. I think we're going to get back to that in more detail. But let's look, before getting into the technical and the legal side of it, let's look at a high level at the cultural sensitivities here, the differences between the US and the EU. And where we're talking about the EU, I think we're largely going to include the UK, where, of course, the rules are pretty similar. So can you just, having worked on both sides of the pond, can you just talk to us a bit about how you see these cultural differences?
Absolutely. And I do sit in a very unique position, having worked in the US, Belgium, and now in the UK. I've had the opportunity and the privilege to experience these different relationships and this different approach to how we deal with these digital investigations. I can say from my time in the US, from law school and then into private practice, a lot of what we do in U.S. jurisdictions and across the various states is very much rooted in discovery, in civil procedure. Pretrial practice is at the core of any matter. And as we go through law school and any investigation that I've worked on, discovery is a key element in any issue, whether it be an internal investigation or a full-blown regulatory request or litigation. When I moved to Belgium, it became very apparent very quickly that this sort of approach to legal matters was not as pronounced in the early stages as what I had experienced in the US. Not to say that discovery wasn't a thing. It just wasn't as pronounced in that stage. Relationships with data was a very more personal approach rather than this holistic all-in approach that the United States had taken. It was a very quick introduction into what was the Data Protection Directive back in those days, but really looking at how do we use data in a little bit more targeted fashion than what I had experienced in the United States. So again, I think this balance between the two has created regimes that are just a little bit different. Germany, for example, is much more cooperative in the way it deals with discovery. They agree on certain aspects of documentation that might be at issue, and then they argue over that, rather than turning over everything in the hopes of finding needles in haystacks, which is largely what occurs in the United States. So it really runs the two gamuts, everything to a much more measured approach. And then now living in the UK, we find ourselves somewhere in the middle of those two scenarios. But I think it really is important as we start going through the various global investigations that we get involved with to recognize that these jurisdictional and cultural differences as it relates to data is going to differ from one location to the next. And we just need to be cognizant of that so we operate in a fashion that's acceptable for each location.
Yeah, that's certainly my experience. I think you'll probably agree that you come across this both at the level of individuals whose data is or might be collected, but also at the level of the individuals or employees within companies whose role it is to deal with these issues, the data controllers or the data protection officers.
Absolutely. Having conversations with a data controller in the United States, there's this much more open dialogue in the sense that I think it's just relatively understood that anything that is in control of the organization belongs to the organization. And there's a little bit less pushback when you start going down the rabbit hole of what might be identifiable, what might be at issue. That same conversation in Spain or France, for example, is going to have a very different outcome. There's going to be questions on individual rights. There's going to be blocking statutes that get brought up. There's going to be any number of different reasons why I'm not allowed to have that data. And again, there's answers to all of those. It's just making sure that you understand the questions that are going to be asked and you put the parties at ease that no data is going to be used in a way that infringes upon their inherent rights.
Yeah, let's look in a bit more detail at the actual law here, which I think is fair because you are qualified as a lawyer as well. You made reference to the old data protection directive in the EU, now morphed into the GDPR, the famous GDPR, which has effectively been adopted in the UK as well. So maybe you could explain for us, please, Dan, briefly how the GDPR operates in this context, and also make a comparison with the US, where, of course, there's a federal jurisdiction, but then 50 state jurisdictions.
Yeah, absolutely. At the forefront of it all is, I do believe, the GDPR, and now the UK GDPR, which is essentially a mirror to the European counterpart. And essentially, this regulation was put into place not too long ago. I think it's only about four years old around since its inaction. It has been put into place to unify all the various regulations that were pronounced across Europe, and really create a single regime that puts control of individuals' data back into the hands of that individual, and then create sort of parameters on the part of organizations that hold that data, and create obligations on their part to make sure that remains secure and that it's not being used in certain ways. Now, there's a laundry list of all the hoops and hurdles that one needs to go through in order to deal with and process and interrogate information as needed on the various matters that we work on. But essentially, what it does is creates a relationship between data controllers who are, as it sounds, in control of that information, and really regulate data processors, individuals like myself and organizations like iDiscovery Solutions, on how to make use of that information for law firms or for regulatory agencies or authorities to get the answers that they need. Now, these different avenues of interrogation, these rights to process information, have to have reason behind it, and it has to fall within a various category to essentially go down or move over to the next step in terms of understanding or utilizing that information. That can range from simple consent of the individual, but could go all the way to for national security reasons, or the sort of pseudo catch-all that we see in a lot of organizations, which is for a legitimate business interest. But really, the moral of the story is that all of these various avenues that will allow you to process data of another individual that can be deemed personally identifiable has to fall within one of these exceptions to move forward into the next stage of any investigation.
And what about in the US, Dan? How would it work there?
So I think the real difference is that a lot of these sorts of rules and regulations are in place in one way, shape, or form in various circumstances in the United States, but it's very dispersed. It's not a single regulation like we have with the GDPR. It's embedded in a number of different regulation. Laws are in place across various authorities with control to enforce it, and for different purposes. A lot of the times they're more subject matter driven, like HIPAA or various other types of sort of data protection regimes within the United States. But the real difference is that it's spread out in various forms across different regulations. Now, what we are seeing is that this is starting to take shape in the various states and at the state level, where certain data protection laws are starting to come into force that are not exactly the same, but are leaning towards and definitely being influenced by the GDPR. And an example of that is California. But what we are starting to see is some of these more data protection focused regulations being put into place at the state level that have some of the very same attributes that you'll find in the GDPR. And maybe we'll start seeing a domino effect in that regard as to U.S. law.
And this is probably a podcast all on its own. So very briefly, Dan, often in these cases, the issue of cross-border transfers comes up. In other words, international transfers, EU, US, or vice versa. Could you make a few comments on how that raises issues in this context?
Absolutely. I think it's the bane of everybody's existence who's ever worked on a second request or a global investigation or anything to do with cross-border data transfer. And if you followed the regulatory and legal history of it, it's been moving around quite a bit in terms of what's allowed to happen and what needs to be adjusted in terms of being a viable mode of transfer. with the various vehicles that have been in place. And again, to go very quickly, we used to have the Privacy Shield, we used to have the Safe Harbor. Both of those got shot down by various decisions in Europe that made it very difficult to transfer data using certain vehicles that were in place on those sort of previous channels and bridges into the US and any other part of the world. Because of the deemed inadequacies of those territories or various territories around the world, those vehicles were essentially ended because the guarantees that individuals were after in terms of their personal rights to their data could not be guaranteed in those locations, thus leaving European countries and the UK now as well to focus mainly on standard contractual clauses, which essentially means that if you are going to transfer data, you have to essentially outline it on a case-by-case basis and really provide the necessary reasoning behind the transfer that the GDPR would outline and those modes of transfer. Similar reasons to why you would be able to process in the first place, but at the same sort of guaranteed levels of security that the individuals would require. So again, it's been a bit of a moving target. Even recently, I think as recent as last year, the European Commission actually outlined a sort of adequacy decision that would even make other transfers more feasible and economical for companies, mostly because they've been able to prove individually at the organizational level that they have those securities and guardrails in place. So we are seeing some movement in the direction of really creating those avenues and bridges to make it a little bit easier for the transfers to take place. But don't be mistaken. I think it's always going to be an exercise of genuinely proving whether or not that individual's rights are being protected. And I think we always have to take that into consideration and be mindful that this isn't an exercise of obligation to the corporations. These are exercises in maintaining and preserving rights of individuals.
I think that's a very good way of looking at it, Dan. Let's move back to the question of collecting personal data when we're looking at both M&A and behavioral antitrust investigations. By M&A, of course, we're talking about essentially merger control investigations dealing with regulators. You made some reference to this earlier, but maybe you could talk to us about how you see it from your current work at IDS, how you see the differences here between M&A data collection and behavioral data collection when we're, again, referring to personal data, which is, in your word, inherent in these processes.
Yeah. So I think with mergers and acquisitions, it really it's almost like a funnel of data that we need to consider, because the requests of the regulators and those involved in merger clearance require so much information to ensure that they are being as deliberative as possible with all the information that is necessary. The requests are extremely broad. Anything from just describing business activities to reports on business plans and analysis of the various acquisitions and the merging of companies. It really takes a very broad stroke against all information that could be at play in terms of understanding why a merger is taking place, what the ramifications of those companies coming together would mean, and what the market in general would do in reaction to those companies coming together. Again, it really is almost everything when it comes to the data that a company holds. The problem at its core is that such data volumes can only be gotten through in a certain amount of time. And the timeframes that are requested, the short timeframes needed to get these documentation over to the regulators is just insurmountable. And as such, you end up collecting a lot more than you probably need in the first instance because of speed. And then you use the various technologies that are available in the industry today to triage that and bring that down to a manageable set that you can start to organize packets for disclosure. Now, because you're doing this huge triage on a large data volume set, there is always going to be personal information found therein. There's always going to be privileged information found therein, proprietary, confidential information that really should not be a part of these sorts of disclosures. And it is paramount to get that information out, not just from a data protection perspective, but just from a management of the disclosure perspective. Differing from that a little bit is the behavioral approach, which is not necessarily this huge broad stroke that you're dealing with in an M&A scenario, but rather the flip side to that, which is I don't know what I'm looking for, or I don't know where to find it. So I basically have an open view to an entire network of data without the right questions to ask, or really an understanding of where to go first. And because behavioral investigations are built around relationships, because these are built around agreements or a lot of more personal driven communications, again, it is very ripe in ascertaining, not in the same sort of collect all scenario in a M&A scenario, but because I'm targeting these individuals for their relationship and their communications, it's going to be going towards personal information that I need to tread very lightly on. So it needs to be more targeted. It needs to be grown as we learn, rather than taking everything. We're using those same technologies, but flipping it on its head and using it much more strategically to find information that we don't know exists without going into someone's data that we shouldn't be looking in the first place.
So that suggests that there are different methodologies that you might be adopting when you're working in iDiscovery as you are now, Dan. So what are the type of workflow options that you see and use, bearing in mind what you've just been telling us about the differences between M&A and behavioral type investigations, or just more generally, what is out there?
Very good question. And I think with M&A, it really depends on your client. I often use the example of the tobacco industry versus the teddy bear factory. One is going to be a serial litigator or have a very strong understanding of their digital environment because they've worked in a big industry, they've gone through these sorts of scenarios before, or they've just had to manage their data as a matter of course and a matter of best business practice. The other, being the teddy bear factory, may be a small mom and pop shop that doesn't really understand its own data or hasn't really had to interrogate it in the past. And between those two, from a digital interrogator or investigator, the clear winner in terms of who I would rather work for in terms of just managing data and getting to the information I need quickly without stepping on any sort of data protection issues would be the one that really has been down this road many times before. Really boils down to how well do you know your data and how easily can we get to the information that the authorities are requesting in a manner where we can avoid some of the pitfalls. That requires, again, very strong information governance. That requires a clear understanding of where to go and what is needed for each individual matter. Again, we'll always have some data protection issues in terms of personal information, but we would create workflows, whether it be review on site and only take out what is necessary for that specific element that we're trying to prove, whether it be to understand if that is housed somewhere else, where we can get information that doesn't necessarily have those same protections in different locations, do deduplication and email threading to reduce data volumes, and really put together a much more manageable universe of documentation to get through using the various technologies that we have available to us, which go well beyond search term analysis at this stage. So using a lot of machine learning to identify this information and set it aside or utilize it in a fashion that meets one of the exceptions within the data protection regimes. From a behavioral perspective, collections are a little bit different because you don't know what you're looking for on day one. I always say it's an exercise in finding something rather than an exercise in finding everything. It's really about using technology to find starting points and then building your investigation off of known facts rather than guesswork. So the way we deal with the behavioral investigations, really, again, similar to what I had said previously, is flipping the approach on its head and doing things a little bit backwards. We're using the technology to identify those starting points and then really grow from there and really utilize the investigative tools in the way that I find most exciting, which is in that more strategic, creative application of the various technologies.
There's maybe a kind of reverse funnel as opposed to the funnel you mentioned in M&A. You mentioned there, Dan, deduplication, also minimization is something we all, of course, come across. How does the data protection or data privacy rules impact that issue in your experience?
Again, a lot of the times you may be working for a global organization. They have their data everywhere. Their data is housed in various cloud environments, in various locations around the globe. And of course, as we work together and as we work in teams, those are our cross-border collaborations. And when we are collecting data, we can utilize the various technologies to essentially make or create fingerprints for documentation. Rather than collecting the same documents from various locations and having a vast amount of duplication and volume increase, which is everybody's frustration, it's better to identify those similar documents. It's better to associate those fingerprints with the documentation that you're after, and then just pull from one single location. And again, depending on the organization that you're working for or working with, there may be avenues in place where we can get to that information without having to go down the rabbit hole of the various data protection regimes. Now, again, it goes back to what I had said earlier about individual rights of protection, which is something that you have to consider no matter where you are in the globe. But at the same time, there are certain documents that just don't need to be collected in one place if you have them somewhere else. So really identifying those duplicates, really understanding where they came from and pulling from one location is one way to reduce that heavy burden of volume.
Okay, let's move on to our final substantive topic, please, Dan. This goes beyond personal data, but you're on the cutting edge of e-discovery work. Maybe you could talk to us a bit about what in the future from the tech perspective. How are these things? You've talked about machine learning. You've talked about issues like that. How do you see a collection of material in the M&A and behavioral investigations or antitrust generally developing?
Yeah, I think it's a very exciting time to be in our profession. And in particular, as we start to see the intersection between the law and technology, what we're being presented with is essentially the impossible. We're essentially being told we have to go through everything in X amount of time and get this information over as quickly as possible. A scenario that 50 years ago would be an impossibility. We couldn't get through the information that we have to get through now without the use of technology. And that mountain of data is only growing exponentially on a year in, year out basis. So what I'm really excited about is how are we using some of these new sources of data to identify or help guide us down the yellow brick road to the information that we're after. We're finding new ways of using structured data analysis to inform a more standard approach to review. And when I say structured data, I'm talking more about non-human created content that is being picked up everywhere and all around us, where clients or where individuals might be becoming more savvy on what they put in email. It's very difficult for an individual to completely remove themselves from the digital grid. And so the more that we can get an understanding of the various interactions individuals have with the technology around them, how do we normalize that information? And then how do we use that structured data to inform what our usual course would be, which is, okay, who said what to who and what did they talk about? Now, as we see all of that starting to come together, it really is providing us a much more three-dimensional view of data interrogation rather than a very singular approach, which is that email communication spectrum. So really, when we start going down those roads, I think we're really moving into an era where we can get to information faster. We're getting to the information that we need and removing a lot of that irrelevancy because we're actually following breadcrumbs rather than throwing spitballs at the wall. I think on top of that, it's in the news, all AI, true AI, GPT type of machine technology, which is really driving a lot of industries and really taking advantage of the sheer power of the machines that we're working with. I think this is another area in the legal community that's going to benefit from it. I often get the comment, when are the computers going to be taking the place of lawyers? And this isn't my answer, but my favorite answer that I've heard is the computers won't take the place of lawyers, but lawyers using computers will take the place of lawyers who don't. And really, that's where I see some of this AI taking place, because it's going to remove a lot of that noise and really put lawyers in a position where they're focusing in on the relevant data. And that's the data that we need to be looking at, and then the data we need to be arguing about and interrogating. So again, I think we're at a cusp of having a myriad of different tools at our disposal, and that just allows us to decipher information at a much more efficient rate, do it at a much more cost-efficient rate on top of that, and really gets us to the information faster than we did before. And as lawyers, that's always been our goal.
As a final follow-up on that, Dan, we've heard noises, or at least to some extent, that even the regulators are recognizing and getting frustrated with the amount of data that they're actually requesting and therefore receiving back. But it sounds maybe what you're talking about in terms of developments in AI and machine learning may actually come to the rescue of lawyers, clients, and regulators a bit, in that you can use that software to dig down more quickly, and therefore get us out of this endless loop of, even more and more information being provided, which is so difficult to actually get through.
100%. I think you hit the nail on the head there. I think that we're at a point right now where without tools like this, it's a virtual impossibility to get to the information that we're after. And no client wants us running through and reading through a bunch of irrelevant information. So these tools are going to be absolutely essential in ensuring that lawyers are getting to the right documents and doing so in a fashion that doesn't waste a lot of time and money reviewing information that it has no bearing on the case. As lawyers, one of the things that I often say when we get into arguments about various truths and untruths, we're using the same documentation and building the arguments around that. All the minutia that's creating noise and issue is not the core of what we do. So getting to those gray area documents is the key. And these technologies will help us identify those quicker so we can have these discussions much more openly.
So now that we've finished with our substantive discussion, we can proceed to our completely unsubstantive discussion. And we always close the show with a couple of questions to get to know our guest a little bit better. So Dan, let me start by just asking you to tell us and our audience something interesting or unusual about you.
Obviously, given my accent, I'm not from the UK, so I wasn't born here, even though most of my family is British. So it is a bit of a homecoming. But the first assumption is that I am American. And truthfully, I've lived most of my life in America, love my former home. But I actually grew up in Canada and spent 14 years there. So I'm also Canadian and grew up on skis and skates. And so, yeah, that's one little tidbit. Favorite sport is skiing. Love to get out on the slopes. Skating, hockey never really stuck. I always equate it to the fact that I was living in Montreal and I was a Toronto Maple Leafs fan. So I think I just got checked every single chance anyone ever had to hit me on skates.
We got 15 inches of snow in Boston last night or yesterday. You would enjoy it if you were here. And of course, we close our show with a question from the Curious Hat, which I will pose to you now.
And now it's time for the Curious Hat.
Just reaching into the hat here, and we pull one out, and it is, do you like to cook? And what is your specialty? And if you don't, tell us your favorite dish that someone else cooks for you.
I do love to cook. I actually find it to be quite therapeutic. Even when I was in university, I spent my entire college days cooking in restaurants to make ends meet. It's become a bit of a fortress of solitude in the kitchen, the monotony of it, but also just really trying to make something that I've never had before and impress family, impress friends. No, I love to cook. And in particular, and this might be the American coming out in me, but I love a good barbecue and grilling out with friends in the back garden. And that also is probably my favorite thing to cook. I like making grilled duck breast is probably one of my favorite meals. So yeah, it's definitely a hobby of mine.
Excellent. I'm hungry for lunch, me.
Yeah, me too.
So I will close the show by saying thank yous. Thank you to Matthew for co-hosting and for preparing for this episode. Thank you, Dan, for all of your insights. And thank you to our audience for listening to this episode of our Curious Amalgam.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.